got a question asking, a property was left to this individual. Okay, their siblings are living in the home. They've been living rent-free for 10 years. Mom gives the property to this person. How do they get them out? What do they need to do? Hi, my name is Rob Wells. I'm the Landlord Boy on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos here. Now, this is kind of where evictions meet trust in estates, okay? And there's going to be a couple of different questions that at least for me, like as an eviction attorney, is going to have to ask. Okay, I need to know how the property was left to this individual. For example, if it was left via like a will, okay, not a living trust, okay, a will, that matter is going to have to generally be probated through the probate court. Okay, this individual might have to get letters of administration or letters testamentary to get the probate letters to become appointed as the personal representative of this state. And then once they have the letters from the court, the letters, by the way, are like the legal authority that the court has appointed the executor or the heir at law to manage the estate, okay, in the probate estate, okay? So once you get those letters, you generally have the legal authority to act in mom's place on behalf of the estate, and you may be able to issue termination notices and so forth. This doesn't talk about just cause eviction or anything. You have to be the legal person that can actually start the eviction. In legalese, we call that the real party in interest. So if it's a probate estate, you usually have to be appointed by the court. Now, the second situation that might happen is mom left the property to their kid in the revocable living trust, okay? And this might apply to this question, okay? If the property was left in a revocable trust and mom passes away, generally, if it was mom's trust, the trust becomes irrevocable at that point, and then that this person right here would basically give notice to all beneficiaries and so forth that they're going to start administering the estate. In living trusts, or trust situations, you don't generally have to go to probate court. You would only go to probate court if there's infighting, basically, okay, that type of deal. And then you might need certain court orders and so forth to show that the trustee has the lawful ability to act on the trust's behalf and so forth, okay? So for in that situation, generally the living trust documents themselves are going to point out who the successor trustee is, and usually that person has the ability to issue legal notices on behalf of the estate and so forth. At that point in time, an eviction attorney could take over the case because the trustee is the legal person, and then we initiate the notices and any eviction lawsuit and the trust's name for the trustee, okay? And the third situation, the one thought of this, is if the property, like through a probate, has been confirmed to the beneficiary basically, and it's been titled into the beneficiary's name, it's just a regular, you become the owner of the property at that point. It's just like a regular eviction. You're the owner of the property now, okay? So it kind of depends on where it's at, where the probate or the estate administration is at, basically, and so forth. Now, one caveat, okay, when someone dies, right, or if no rent's being paid, you generally don't want to accept rent, okay? Because in California, at least for month-to-month tenancies and anything that's a periodic tenancy less than a month, basically, when a property owner dies or the tenant dies, pursuant to Civil Code Section 1934, the periodic tenancy, or that month-to-month tenancy, terminates basically upon notice of the death of the landlord or the tenant, basically, of all tenants, okay? So if you accept rent, for example, during the estate administration, you probably created another tenancy, and then you're gonna have to terminate the tenancy, possibly with just cause and so forth. The Civil Code 1934 termination would apply even if just cause is required under the local ordinance or so forth, if it is a periodic tenancy, because in the Civil Code itself, death by operation of law terminates a tenancy. So that would be cause, and at that point it's advisable to get an experienced attorney to issue the proper notices, because you have to give notice of the death, and depending on the circumstances, a 30-day notice may be warranted, advising the occupants that they're going to have to vacate, or landlord's going to file a unlawful detainer, that type of deal, because of the termination due to the death. So your mileage is going to vary. It's going to be highly factual, but terminating a tenancy after a death usually happens by operation of law, and you basically have to be the right person or the real party in interest to terminate the tenancy. So hopefully this questioner here is the trustee or the personal representative of the estate, or the property's been titled to them already, and that gets them into the courthouse doors. And at that point, the analysis of whether you're gonna have to have just cause or not to terminate the tenancy will be determined at that point. So owners, landlords, people that inherited property, if you've just become an owner of property and you got people inside, like siblings and so forth like that, and you need help, you're in the Northern California area and you need to get rid of them, feel free to reach out. We might be able to help out. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. See ya.